Order. All would rise for the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America, and to the republic
which stands
under God,
the nation,
indivisible,
under God,
with liberty
indivisible,
and justice for
liberty
all.
and justice for all.
Okay, if you could do roll call, please. Grace Reed.
Here.
Jeannie Hill.
Here.
Charles Stadelman.
I'm on Zoom, but I'm here.
Bill Flynn.
Here.
Scott Liebertor.
Here.
Richard Gilmore.
Here.
Vicki Drumheller. Here. Tim Borden. Here. Sharon Herman.
Here.
Susan LaRusso.
Here.
Felicia Hollerman. Here. Wanda Simmons. Here. Nicholas Shaskowski.
Present.
David Moore. Here. And Preet Singh.
Here.
Okay, we're going to start our meeting with unfinished business that we asked the attorney to do a little research for us. I hope you didn't receive the email. This was a little late today, but you have this paper on your desk for the second piece. But we'll start with A, section 202, eligibility.
Okay. Oh, I can cover some of the stuff. Most of the things that we talked about, I mean, if we want to put some of these things in, we can. We cannot put in anything about bankruptcy. That's a federally legally protected status. So if we were going to exclude somebody because of bankruptcy, and also as we talked about, we can't put arrests down. We could put convictions, but under state law, the definition of being an elector, what we would basically be doing is deviating from the law that says that in order to run for office, you have to be an authorized elector of the jurisdiction that you're running for. And that determination is made by state law. So there's not been a lot of challenges. Cities haven't tried to get creative on that and exceed it. So there's not any case law on it or attorney general opinions, but generally speaking, it's because it's spelled out pretty clearly in Florida statute that it says that in order to run for office, your standard is you have to be an elector. In large part, that's because the way that is all structured, and when it comes to elected positions, is they want to put it as much in the hands of the people as possible. That's why we have elections. So they try to not put self-imposed hurdles on things. So we could, I don't know if we want to be a test case. I don't know if we have anyone out there that would challenge us. Maybe we do. But it would probably end up proving problematic. Now, there are the cases and the guidance on residency. I mean, a lot of places will do 2 years instead of 1 and things like that. And then when it comes to us coming up with language as far as defining residency, we could work on that. So if you want to focus on that and forego the other stuff, or if you want, we can come up with language for all of it. So.
Well, I do think at the bottom of this, we have some things that are kind of within the city's purview to check, which would be to change to 2-year residency, civil litigation against the city, all taxes, liens, and fines paid with any restitution. So those bottom 3 could be additions without really stepping on Florida law, couldn't they?
Yeah, I mean, we could. The one thing I would guard against, there's an adage that they teach us in law school that says that bad facts make bad law. We want, and we know the city has gone through a lot in the years, the last several years. We want to be careful not to react and maybe create bad law because we're looking to try and avoid bad facts again. So we could certainly come up with something and keep it within the realm of being legally defensible, but I think we want to be careful not to be too overreactive, I guess is what I'm saying.
Instead of having it in the charter, could it be on the application?
That yes, and that would probably, and that would be the better way. And that's where a lot of municipalities do that, because it's a matter of notice. Then you put on the application, that application, gets posted as, it's public record. Most places put it on their city website, and you can click on the candidates and you get their filing paperwork and everything. And then at that point, if you require that they disclose certain things, disclose any liens they have, disclose any, that would be the better way. And that's, again, more the objective of the state of, we're leaving it in the hands of the voters. We want to leave it in the hands of an informed voter, so let's give them all the information that is available, but not restrict it ourselves, because and actually a lot of the cases that do exist out there where there's fights over eligibility, they usually get really ugly, but right now they're usually over residency, and that is whether somebody's really a resident. They have a big house in Tampa, but they have they just rent a little 1-bedroom apartment in some other city so that they can run there or something like that. Those are the type of cases. But they always get very protracted, and the courts really don't like them because, again, they want the public to decide.
I know we probably have some strong opinions on some of these things up there, so let's have some more discussion about this. Tim?
So I'm a very strong proponent on, I understand that the rights are restored after a certain amount of time, but I don't feel anybody should serve that's been convicted of embezzlement, theft, forgery, extortion, perjury, those things on that list, and including sunshine law violations. And, I understand if we want to put a cap on it, but if any of these crimes have been committed in the previous 10 years, I think that should go in the charter. I mean, I don't know about you guys, how you feel. Do you want somebody like this representing your city that was convicted of extortion, convicted of perjury, convicted of taking a bribe? I mean, nobody like that should be serving in public office, in my opinion. And I understand people make mistakes, this and that, but these are some pretty hefty things. So I'd say in the previous 10 years, if one of these things have been if one of these things apply, you're not fit to serve the city of Sebastian.
Madam Chair?
Yes.
Yeah, and I agree, but I think that if something comes up in a campaign where you have a competitive campaign, I mean, the voter's going to decide one way or the other. I mean, if I'm running against somebody that's has all those strikes against him, I would hope that I would prevail. And if the rights have been already established where he has voting rights back, I don't see how you can put that in the.
So what if there isn't a campaign? What if it's an uncontested race and there's nobody else running, and somebody, they just got convicted of embezzlement, they had their rights restored 6 months ago, and the crime was done 2 years ago? Do you think they're fit to serve public office?
No, but I don't think we can judge that. If they're a qualified elector, they're a qualified elector, and I think that's state law. Period. I mean,
I have a question. I agree with both, actually. But we have the question on the application now about whether or not they owe money. That was added for this election. Could there be 2 questions, or all of that combined into one? Do you owe any monies, or have you been, in the last 10 years, have you this, like you had worded it? Yeah. Like Tim had worded it, yeah. And that way, if someone from the public goes and reviews the application, they see that. So the information is out there, and I can almost guarantee you that the way Facebook is, if someone sees it, they're going to announce it to the world.
But the problem, Grace, is there's a lot out there that don't pay attention no matter what Facebook says.
You got a point there.
Look what we ended up with a few years ago.
Tim?
So just a question for the city attorney, just understanding the city aspect of it. So what harm would it do the city, or what would it open up if you did do that? Let's just say we did say, we want to put something on a cap, 5 years, 10 years, or something for one of these major crimes. And when I'm talking about these major crimes, I'm also adding the sunshine law violation stuff on there as well. I mean, what does that do? How does that cripple the city?
It doesn't. I mean, it would only open it up for challenge, is what I was saying earlier. One thing that might help this conversation, and if you would indulge me and we table it to the next meeting, is let me come back with a very detailed process of what it means to get your rights restored. Remember, there's two different functions. Getting your rights restored for purposes of electing, being, carrying a gun and voting and all that is different than having convictions expunged from your record. They're two different things, they're two different processes, but they're both very onerous processes. And that might help us in deciding this, because because it's not easy. Neither one of them is easy. And I think we probably need to fully understand exactly the process, because like the example you just said, you were convicted 6 months ago and you got your rights restored. Well, that's, not going to happen, because you can't do it that fast. But in order for us to really be informed on what it means, let me bring that back as to the exact process and some average length of times and some case studies as far as how long it takes, because the restoration of rights might be so onerous that we could rely on that versus putting anything in ourselves. So let me check that out, and we'll
Would you mind checking the sunshine law stuff?
and we'll
as
do the
well?
sunshine law, because that's generally a misdemeanor, and in most cases even an infraction. It's actually very rare to have misdemeanor convictions on sunshine, but it would be something that we'd have to look at separately, because it doesn't take away your voting rights. A conviction on a misdemeanor doesn't. So we'll, absolutely, I'll bring that back too.
So the question would be, if you put that in place for the sunshine law, and then somebody was going to run that's been convicted of that, they're going to take the city to court, and we're going to lose.
Well, that's the problem. I've definitely, part of my job is risk management as well, and because that hasn't existed and there's not any cases and there's no statute on it, so at that point we have to make pretty much do an analysis as what is the risk of having this challenged and losing, and what would that mean. So I'll definitely bring back a more comprehensive
That's
look.
why I was asking those questions,
Yeah.
Just curious
Yeah.
what it does to the city at the end of the day. But, we're all here to protect the city, and, if there's a way we could protect it and still covers the stuff, I think we got to really look at it.
That's the thing, when we get into areas like this, there's no bright line, because it hasn't been decided already. So at this point, we have to do an analysis to see what the risk is, and then at that point, make a determination of, this has not been challenged before, so we would be on the cutting edge. Is the risk worth it? I mean, is it a big enough issue for us to go ahead and say, let's put this in place and be that test case if necessary? So,
Jeannie?
I have a question probably for you, Jim. Fill out application for city council. Who's responsible to verify that information? From what I understand, Leslie Swan doesn't do it. And from what I understand, our city clerk doesn't do it. So I basically can put anything on that application. Who's going to verify it?
You're
Who's
right.
going to tell me?
the way
Where
that,
is that?
and like I said, a lot of the cases as far as like residency, if somebody's running and they don't live in a district, they don't live in the city or whatever, that has always been a situation where the clerk is not responsible, because it's a ministerial act.
Right.
It's like They check the boxes. You filled out every spot on here, the check's in the right amount and things like that. And that's all they're responsible for. And the supervisor of elections is pretty much the same. They just, when they get the package, make sure everything was filed properly, but they don't verify the veracity of what's on the forms. They just make sure the forms are filled out properly. So the person who's responsible has to be a citizen, and in most cases, it's an opponent. I'm running against you. I know you've lied. I have to bring that up, or I have to file the court case to challenge what you put on your documents.
And by that time, it could be too late.
Yeah, I mean, sometimes the courts will fast track it and get injunctions in place, but they're very hesitant to. There was one, it was Vero Beach, where they kept somebody off the ballot, and the judge ended up ruling on it after the election. They had to have a special election. It cost Vero Beach like $80,000 to hold a special election.
And we don't need to do
because they had left somebody off the ballot, because the clerk there had made a determination that they weren't a resident. And, when they found out they were, the judge told them they had to do the election over again. So it ended up costing them a lot of money. But yeah, that's the problem, is that we file a suit, you try and get the judge to rule quickly, but judges
Their own time.
do what they want when they want. Yeah, that's
What I'm saying. We're doing all this work trying to get it, and if nobody's there to verify it, it's up to Richard to confront me, or too bad.
Yeah.
It does kind of sound, though, that if we added these concerns to the application for the candidate to fill out, and they fill it out and lie on it, there is I'm assuming there's an attestation at the end of it.
Yeah, and that would be the thing.
So, and I'm not sure the charter committee even has a role in that, because that's more operational, that checklist. But if it was included there, at least that would give an opponent and citizens that are concerned and look over the material an opportunity to get word out about a candidate versus adding it into the charter where it seems to have a rocky road in front of us.
Yeah, and that's would be the better route, rather than keeping somebody off the ballot because you think they're not eligible. You let them go on the ballot. They've lied on their form. You let them go on the ballot, and then if it's determined after the election that they are not eligible, it's easier to remove somebody that was elected than to, do an election all over again. Depending, of course, on how our charter says vacancies are filled. So, some places, some cities, and Palm Bay is one of them, because they just changed their charter. They do a special election for every vacancy. They don't just appoint people to vacant seats, which is crazy, because that's just adding cost to everything. But yeah, it's always easier to, and the judges see it that way too. They're like, I'm not going to rush and rule on this thing to accommodate an election schedule. I'll rule when I rule, and if this person's elected, then they can be removed. They see that as an easy remedy.
So is it against, what is a law or something if we can get somebody to verify that information on the application? Can a city appoint somebody, like a background investigator?
I
don't know.
That is an interesting question, because again, you would still have that. I'm not sure that could be done, because again, if they're writing everything down, because it would still end up in litigation. I guess that's the case. So I come in and I file, the clerk or somebody, says, oh, well, this isn't true. And you say, yes, it is. And you're going to end up in front of a judge anyway to make that determination. So I guess the plan is, or the idea has always been, well, we're not going to make the city clerk or the supervisor of elections get into that role of being the verifier of facts. We're going to say, if you want to have, because it's kind of a standing thing. It's like who's going to be suffering the harm? Well, I'm running against this person. I'm the one that's going to be able to file and have this challenged. So.
Would it not be
perfect
feasible to go to, let's say, the police department that's paid by the city for some type of that?
They have like background investigators.
Right.
I was just curious.
Yeah, I mean, that would be, again, pretty much an unending, so we do background, basically we'd be doing a background check on candidates. And I'm not exactly sure how much, because so much of the CGIS information is restricted for only certain purposes. And so we would have to look at that really close to, because we couldn't use those databases improperly. You can, and this doesn't technically fall under an employment background check. Even though that's the way we might see it, elected officials aren't considered employees.
Right.
So you're not doing an employee background check, you're not doing a criminal investigation. So, we'd have to kind of figure out if,
Where in like
Where it
NCIC,
fits,
FCIC, the code falls for what you're doing.
So one of the things that is, anyone still interested, I actually really liked the 2-year residency, which gives someone an opportunity to be here a little longer and to imprint. My first year here was all just trying to figure out where stuff was. So, and I also think that gets away from, people move in and they move out. We have a lot of people that are in and out of the city. So what do you feel about the 2-year residency to replace the 1-year residency?
I agree.
I second.
Okay, all those in favor?
Aye.
So we have a recommendation to change to the 2-year for residency. I don't know that there's a lot more that we can talk about tonight on this particular subject.
Yep.
So is everyone okay with us moving on?
Do you need a motion to table?
I don't know if you want to make a motion for you're going to bring up.
Yeah, I'm gonna bring it back.
To
So-
table it to the next meeting?
So we can have that on old business again. We'll keep it on old business.
I'll make that motion.
Okay, second?
Second.
All those in favor?
Aye.
Okay, so we've tabled that to a next meeting of March 2nd, 2.02. We'll look at that again. Okay, we're going to move on to section 2.05 compensation.
Yeah, just real quick, what I had provided is, I did up, the top of the page you got was basically the motion and vote that you guys had talked about of doubling what the council and vice mayor make now, and then putting the mayor up, not quite double, because you said to do 600 and 750. What I gave, because there was so much discussion about it, I gave examples of 2 of the other styles that we talked about, which were basically formula styles. Because obviously, if we want to do either the top one as is or adjust those numbers, that would be the way that one would end up looking. The other 2 are the formulas which local jurisdictions around here use. One being a comparison or a percentage of what the county commission makes. The county commission is decided by state statute, changes every year, changes or doesn't change, but it's determined by the state every year as to what a county commissioner is going to make. And so then we could have ours be a percentage of that. And so then it fluctuates based upon the economy and everything, the same way theirs would. Or the bottom one being the per capita thing that we talked about a lot as to using the population. So I plugged in formulas just so that we could get a visual of that. You guys have already voted. I mean, it's, again, it's kind of an informal thing, or if somebody wants to do something that supersedes what you decided last time. But I just wanted to give you examples so you could put your eyes on all 3 different styles.
Let's have a little discussion. Richard?
Madam Chair? Yeah. If you do the math, 80 hours a month, $600, that's $7.50 an hour. And I know Jeannie Hill can attest that her son spent at least 20 hours and sometimes many more hours a week on city business. And when you're running a business like he was, the 20 hours that you're spending on city business, you're not out getting clients. You're not making any money for yourself. And so I always looked at a council member as kind of like a board of directors. A board of directors on a $50 million corporation, which is what this city is right now. When I was on it, it was 25 million. But anyway, if you look at what is normal for the compensation, you know, Vero is a city of 15,000 people, and we're 27,000. So we're almost twice as big as Vero. I would make a motion that we, instead of going to $600, that we'd go to $1,200 for council members and vice mayor, and $1,500 for the mayor, along with the annual percentage increase given to general employees. That would at least take it up to $15 an hour, which I think is reasonable.
don't think the-
Richard, before, would you hold back your motion so we can have some more discussion?
Well, it won't be necessary if I don't get a second.
Okay.
I don't think the general public will accept anything higher than doubling. I think that's even a stretch.
Yeah, Madam
Not that
Chair, we
we're
need
not
a second,
deserving of
otherwise
it.
it's a moot point. So
Do
if
we
I don't
have
get a second, it doesn't
to the
matter.
motion? Wanda, you second?
No, I just have I must be old school. I thought council did not get paid, that it was volunteer.
Okay. Well, they're getting paid those other fees there, $450 and $300 is what they're getting paid currently.
I was going to say, I would second Richard's motion, because if you do look at it and look at the population and what we looked at last week for the city of Vero Beach, I mean, worst case scenario is the voters don't vote for it, and they wouldn't vote for a 300 increase. I mean, I know you said last week that we would have to put on there kind of like a detailed, this is why we're wanting to increase it to that.
Well, we would be allowed to do an education campaign as to, you know, the current history and, you know, we could put whatever. What the law says is we can't advocate for either a yes or no vote, but we can educate the public on things, so.
Tim?
I don't disagree with you at all as far as the salary thing, but I look at it from the voter perspective. So right now they're getting $300, and to up it to $1,200, I think a lot of people are going to be shell-shocked, and I think we're going to be right back to where we were with them only getting $300 at the end of the day. That's my concern. I mean, I'd like to hear some other input, but
Well, remember-
I don't see the voter voting to, I mean, we're talking 4 times, which I think it getting past or slim to none, unfortunately.
Sharon?
I totally agree. I don't think we'll ever get $1,200 to the voters, especially with the economy and the way things are right now. I think we have a reasonable chance and a reasonable expectation of the voters to understand that the $300 hasn't been raised in, what'd you say, 20 years?
2006, I believe.
2006, so yeah, almost 20 years. You know, so to expect to double their salary up to $600, you know, they would, I think that's something that the voters would agree with and say, well, yeah, $1,200 to raise their salary for what the majority of the council people will tell you they treat as a volunteer position. They do it because they love the city. They do it because they want to help the city. They are not in it for the money. If you ask them, if you're in it for the money, of course they laugh. Okay? But I think they do deserve some type of an increase in their compensation, and I think the 670 and 750 is reasonable and possible to do.
Okay.
So can I throw out an idea too, just to think, is, because remember, this is the language we can come up with. We could do stages too. Like we could do, you know, in 2026, it'll go to 600 and 750. In 2028, it'll go up to maybe 820, and something like that. So we could build it, because we're not going to have another charter review for 5 years, so we could maybe have it go up now, then 2 years from now, then 4 years from now, and kind of stair step it. It's going to make for a longer, wordier passage in the charter, but it would have a purpose. So just an idea.
Now, we have to remember, they're not just getting 450 or 300 a month. They're getting that extra 300. Each one of them gets an extra 300. So the mayor's getting 750 right now a month, and the council members are getting 600 a month right now. If we up it to 700 or 750, does that 300 still get put on top of it, which then gives them their, 1,200, 1,300 a month? Are there going to be people out in the public that realize this and are going to fight it really hard? Or afterwards, if it goes through, we're going to have torches coming at the city hall. What did you do? You lied to us. So we can't lose sight that they do get that extra 300, because back then we knew that there wasn't going to be, they weren't going to swallow a raise to the city council. So that's when that ordinance went in.
Bill, did you have something?
Yes, I know a large number of people in Sebastian are already upset about garbage collection. I'm not bringing that up, but with the increase of property taxes, I don't think it will pass. We also remember that we are giving a percentage increase that the employees get, so there is an elevator up. I think that stands the fairest and the best chance of passing. It's community service. I mean, it's not a career field. That's my thoughts.
Sharon?
I understand what you're saying, Sue, about that 300, but the way I understand it's written, it's expense money.
But they don't have to prove anything.
Well,
They just get the check every
Well,
month.
they don't, but I, at the same token, I think between gas and things that they attend where they have to pay for their own meals and things like that, it seems to me that if they don't hit exactly on that 300, they probably every month hit darn close. So to just, I understand why y'all put it in at the time you did, but I think it is more of an expense account type of increase now, rather than to look at it as, and they get the additional bump. I think they can probably justify their expenses with that pretty easily, and without it, they would be going into their $300 that they make to cover, to be a break even. I don't know.
And that's kind of what I was thinking as well, because, I mean, you got wear and tear on your vehicle, oil changes, gasoline, It's just Sebastian. I understand that.
Honestly,
But
I
that
do
actually, if I may, it's actually not, because council members are on the Treasure Coast League of Cities and all of these other meetings, and the meetings are in Treasure Coast League of Cities meets in Port St. Lucie most months, and all of that. And so they're driving all over the place, and they're having lunches, and they're doing all kinds of stuff. And the trade-off to having a flat rate expense account would be having them turn in receipts for everything, which poor Brian would probably have to hire somebody in finance just to process all the receipts and make sure that the checks got cut to reimburse them for, this meal and this, tank of gas and everything else. So it was just seen as easier.
And it probably would come out more.
But yeah,
It probably would.
they definitely do a lot of travel. Or even at the meetings, you can hear them talk about like the items that are in front of them, and they're like, yeah, I drove out and I looked at that property, or I looked at that project, or whatever. So it's more than just around town. So
Jean?
I think everybody's going to be surprised. Most of the city of Sebastian residents don't realize that they get that extra $300 a month for expenses. I mean, us that have been involved in the city, we do know that. But the average person out there, they don't realize that they get that extra $300. So I'm just looking at it as, okay, city council gets basically 600 as a person that doesn't know anything about the city.
Yeah.
And then you're
Well, we also
up 'em.
have, I think
You
that
just-
most voters would concur that even if councilmen were making zero, that if they did something and representative of the city and had to drive, I think most individuals would say they should be paid for the expense of what they're doing for this, in representing the city. And $300 does not go a long way, certainly with meals and travel and paper, all the other things that go. So, and I do think that it would take a full-time employee just to shuffle receipts and then shuffle them to Brian for BB with a date on it, and then shuffle it to accounting and all those pieces. It would cost us more as a city probably if they didn't have just a standardized, here's your check for expenses. And they may not spend it all in 1 month, but I bet on some of the months when they're going up to Tallahassee or doing some of these committee meetings, that they might spend $400 that month also.
So
I
is
think
it,
it's kind of a very different issue, expenses versus what their pay is also.
real quick, is it, whose responsibility will it be to write the educational note in that question? Would you come up with that?
Probably.
Okay. So I think that will affect the voter's decision a lot, especially if we word it like, hey, in the last 20 years, this has not been raised. Just as me as a voter, if I were to see that, I'm like, okay, we definitely need to raise that. I'm sorry, but $300 like is nothing. And the expense, most of us had held jobs where we had the expense. We don't even think about that. Like, that's just, we have to spend that, right? That's for my work, like shoe allowance, clothing, like, you know, I need to wear clothes. I have to use that money, you know, to come to job and all that stuff. So I think when we put that note for that educational, it's going to be very important. And I think we should bring this up if you can come up with verbiage. And I think if we can review over that, how you word it and how it would, if we were voting on that and we were to see that, how we would feel.
We will see everything before it goes to council. So.
Well, I get that, but if we need to work on that note, right? Like
Yeah.
reword it, or if we don't like the way it's worded, I think that might affect a lot, but we definitely need to increase that.
Yeah. So any more discussion on this? Because we have a motion and a second from Richard that is for 1,200, correct, Richard?
Yes, that's correct.
And 750, was 1,200 and 750, is that?
1,200 and 1,500.
1,200 and
1,500.
1,500. So we have that motion standing, so would you like to take a vote on that, a yay or nay vote on Richard, because we have to dissolve that motion before we go anywhere else. So Grace?
Yes. There's probably 14 people in here that are just going to disagree with me. But I know of a few of our leaders that don't want to raise, number one, don't feel like they need it. I don't think the citizens of this city are going to raise the money. I mean, vote for any amount of money that you raise, because they never have. But I do think there should be maybe the annual increase, like the percentage. So my thoughts are leaving it as it is with just adding the bottom statement about the annual increase, but that's just my feelings.
Okay, so let's handle the motion that's on the floor for the 1,750 and 1,200.
No.
I'm
The
losing
motion
all my
was,
numbers.
the motion is that the
1,500.
1,500 for the mayor and 1,200 for the council members and the vice mayor, along with the annual increase given to the general employees of the city. That basically gives them $15 an hour,
Okay,
which is not a lot of money, so.
all right,
That's
so
which
is pretty
so
much
we have the
minimum wage.
motion, we
Yeah.
have the second. Let's do a hand raise. All those in favor of this motion, raise your hand. 1, 2, 3. All those opposed? Okay, looks like the motion does not carry. So let's go on to further conversation.
So I'd like to make a motion that we do the first option of giving the mayor 750, vice mayor 600, and the town council 600, because I think that's the only thing that has a good chance of passing, and they do deserve an increase.
Are you adding to your motion the annual increase that's also underneath there at the same percentage as given to general employees?
I don't know if that would fly. No, I'm not going to.
So you're not adding that to your motion? Okay.
Somebody else wants to
Okay.
add to my
Madam
motion?
Chair, can I chime in?
Sure, go ahead, Charles.
I'm glad to see everybody here tonight. Sorry, I'm still on the road. My schedule, I thought it was yesterday, actually. I showed up yesterday. What I would like to do, and this stems from some of the conversation earlier, that we are a much larger city. We have to bring this up into the century that we live in now. Obviously, $300 wasn't it. I would like to explore the third option that we had out there, seeing how the first motion failed, where the council is paid whatever the number was. I think it was 20 cents or 10 cents per citizen in Sebastian, or per however that has to work out. And I think it's similar to what Palm Bay is doing. I'm not sure 100% on that, because I am on the highway. And I would like to talk about that a little bit. And the reason is because, one, they're trying to take down the property taxes, and it might happen. Yeah, I may not agree with it, and people do agree with it, but if they take out the property taxes, I don't know where city services are going to go. And if we're just charging per citizen at that point, whatever it is, 10 cents, 20 cents, I don't know what their formula is. And we take it out of the property tax formula where it's more of a city tax. And I didn't know what people were thinking for or against that. And that's one way I would lean to it. The other reason why I would go that way is because then the city council is getting paid for every single person that they're representing, including the new people that are going to come on. Because 300, 600, that's paying for everybody now. That's still kind of lagging as we look at what other cities are paying, even in the cities that are smaller than ours. And then the city council, we don't have to worry about increases. It's based on who's here. And I'd like to know for or against, and to see if there's any traction for paying it that way. That's all I have.
Okay, well, thank you for your input. We do have a motion on the table right now for the straight increase.
Yeah, Madam Chair. Yeah, I'd like to amend the motion. To include to the original motion.
I think Nick has to amend his own motion.
No, he has to accept it.
He's going to accept it.
Yeah, but
We've already
was there
voted
even a
on it
second
once.
on the
Pardon me?
motion? Was there a second?
No.
I hadn't heard a second. Oh,
Yeah.
so there was a second.
Okay, yeah.
So now, through the discussion, if there's an amendment proposed, they
Just
would
a
have
little
to-
discussion real quick. And the reason we did this last week, or 2 weeks ago, with the annual increases, that way we don't have to wait 20 more years for them to get another small raise. That way they're getting, I mean, it's such a minuscule amount anyway, but I'm in support of just the way it sits, as we talked about 2 weeks ago, a week ago, whatever it was, just as it's written on the paper, the 750, the 600, with the annual increase at the same percentage rate given to city employees. So if you want to amend your motion
I'll
to that,
amend my motion to include that.
then I second that. Thank you, sir.
Okay, so we have a motion and second for the straight increase with the elevator as it sits. Let's do a hand, or is there any other discussion before we take a vote? Okay, all those in favor?
Aye.
All those opposed? Okay, all right, so the motion passes for the top one. That's good, okay. All right, so
Finally,
we've got through
something done.
compensation, you don't have to talk about it.
There we go, yeah.
All right, we are going to move forward on section 2.07, which is on page 9, I believe, where it starts.
Can we
Yeah.
hours?
2.07. We got to the mirror and voice mirror. Actually, it's on page 10, general powers and duties. So this is a lot about what city council can do. And the section 2.07 itself is really just the introduction. Does anyone have any comments on that paragraph?
Sorry.
That's okay. So if we go to section 2.08, which is vacancies, forfeiture of office, and filling of vacancies, this has A through F, so we have a long way to get through, so we're going to take those one at a time. This was amended in the last meeting substantially. It did a lot.
Yes, it was.
So under item A is of what a vacancy is. Any questions about the language there? Comments? All right, moving along to forfeiture of office. And this is there are 4 areas in the charter where a council person or mayor or vice mayor would forfeit. And the first one is lacks at any time during his/her term any qualification for office prescribed by this charter or law. And 2, violates any express prohibition of this charter. 3, is convicted of a crime involving moral turpitude. And 4, fails to attend 3 consecutive regular meetings without being excused. Conversation, Richard.
This might be where you want to put in sunshine violation. Might be a good spot for it.
Okay.
So as an addition, do you think, or just put it under 3? Because it would have to be a conviction, correct?
Yeah.
Yeah, right.
Isn't that covered under number 3?
Yeah, that's what I was saying, yeah.
It's not covered now. Sunshine violation wouldn't be considered moral turpitude. So,
It would or would not?
would not.
Would not.
Would not.
So if we put some language there, would it cover everything, whether or not it was, because you said it could be an infraction or mostly a misdemeanor. Can we make it so it doesn't matter what the conviction is under sunshine law? If it's a conviction, it means they forfeit?
Well, I'll
You'll think about
yeah,
it?
no, I'll have to do some research on that because, again, saying conviction of a crime is fine. Generally, if the state attorney drops something to an infraction level, it's because they're taking it out of the criminal arena. So, being found guilty of an infraction is not always considered a conviction of a crime. So we have to parse our language carefully. So because if you get a traffic ticket and you get found guilty, you don't have a criminal record now. You have a traffic ticket. It's an infraction. Life goes on. So
I recall quite a few years ago, there was a council person who inadvertently broke a sunshine law rule, and he got slapped with a fine, but he was not removed, didn't have to be removed, paid the fine, and went merrily along.
Okay. Did you? Anyone want to talk about Sharon?
I'm not sure where this works, because this is for removing a council person from the office. But if we're talking like the sunshine violations or, crimes against the municipality, something like that, where does that fall for somebody that has a conviction that gets elected? So as soon as they get elected, then we say bye-bye?
Well,
Just throwing that out there.
If you look at section C, suspension, it does say that a consul or mayor may be suspended if he/she is arrested for a felony or for a misdemeanor related to the duties of office. So wouldn't a
Okay.
sunshine violation
Yeah.
go there?
Yeah. Yeah, I didn't see that.
So I think we're covered.
Yeah, okay. Moot point.
Yes, sir?
You're looking at suspension. The reason it says arrested is because this would be a situation, and this, you know, we go to the governor to get an elected official either suspended or removed. The governor will only suspend somebody once an arrest is made.
Okay.
And actually, it's not even true. They want to see the charging document. I've gone through this before. They want to actually see the charging document filed. And then they'll suspend. He won't remove somebody until there's a conviction. Because again, just because you're arrested, you know, all they need is probable cause to arrest you and to charge you. But then they need to prove it in order to get a conviction.
But
So
the suspension still takes them off the council and voting.
it does.
Okay, so that probably would be what we want to have happen, right? Because we do want everyone to.
Well,
have due
and that's, right, but that's also why we do need to think, and there's probably a little bit of inconsistency here, because if we're going to suspend them because they were arrested for a sunshine violation or charged with sunshine violation, but then once they're convicted, if it's considered a misdemeanor, they go back. So they're suspended the whole time they're pending charges and then can come back on once they're convicted. So there is a little inconsistency here that we're going to have to iron out, so.
Any other conversation about 1, 2, 3, 4? So I thought we'd be covering under suspension from office. Actually, so.
The sunshine violations. The first thing if they're arrested or whatever, the first thing you're going to want to do is suspend them, correct? If they're arrested.
yeah.
Because just one little step ahead of myself. In C, under the suspension of office, it talks about if he or she is arrested for a felony or a misdemeanor related to the duties of office. So that's where I think the sunshine violations should go. And there's one other step too, but I'll wait until we get to C.
So that C, suspension from office, probably would cover almost everything on that list.
Yes.
Yeah.
Really, without the conviction, just an arrest for any of those offenses, like we were talking about, theft, you know, all of those things that could impact their position with the city, for sure. So does anyone have any more comments on C, or just leave it?
I have a question. Who determines to tell them they're suspended? Is it the whole council? Is it an automatic, oops, this happened?
The way this is set forth, to be honest, it's getting more common for cities to put this in their charter, and I'm not sure it's legal. But we have it in D. It talks about the special hearing. City council, with the advice of the city attorney, will hold a special hearing to consider to vote or suspend a council member. The problem is, if you look at state law, it says only the governor can remove somebody from an elected office. So, and that's why I say a lot of cities are starting to put this kind of stuff in their charters, and yet it hasn't really been tested yet, because if you look at state law, it says only the governor can remove an elected official. So
But suspension isn't removal.
it's temporary removal. It's considered a temporary removal.
Okay.
Because the whole thing is, the way the state looks at it is, the 27,000 voters in Sebastian said they want you on the council. Are we going to let 4 council members decide, or are we going to let a committee decide? No, since that's an elected official, they don't, you know, it's got to go, you know, things roll up, you know, so it's got to be somebody higher that's going to remove them. A judge would have that authority, but usually you don't have, you know, and there, you know, there can be sentences handed down, or even plea bargains, where somebody, you know, gives up their right to hold elective office, or a judge may order that. But in this kind of situation, generally, it's going to have to be the governor. And the governor's office, they have a whole system in place for how to remove an elected official and what recourse the elected official will have to challenge it and everything else, so.
So are you saying we should not have these in our?
I'm saying D might be problematic, but, like I said, they've just, I know this was probably just put in at the last go-around.
Yeah.
And again, like I said, there's been a lot of cities putting these in. They have not been challenged yet as to whether there's really that authority. Can the other 4 members of council, kick one of their members off? It's kind of an open question, so.
I have a
Grace?
couple things. We're on C, right?
Yes.
Okay. First, I just want to understand better. You had said that the governor is the one who removes anybody from an elected office. We removed somebody through a recall. Governor didn't have anything to do with it.
Recall elections are, the electorate, definitely, you can vote somebody in, and there's a system at all levels of government to have recall elections to remove somebody, yeah. No,
Gotcha. And the second thing is, with it worded, could we, I don't know if we can or not, but it says for a misdemeanor related to the duties of office. Can we just remove the duties of office? I mean, because there's some things that people are might get, we've already put Bill on the council. Well, a year down the road, Bill does something really dumb, and it's not really related to his duties that he's sitting up on the council, but it puts a shame on this city or something like that. So can it be from just being arrested, it can be suspended, or does it have to be the duties of office?
I mean, you've got to try and broaden our way of thinking that there's a lot of things, and maybe you can chime in on misdemeanors in general. I mean, there are things that a person might step into that they get charged with a misdemeanor that may not, in the grand scheme of things, be something that would disqualify them from usurping the will of 27,000 people in the city that wanted somebody up there, and now, they got into a little scuffle with the neighbor, and they kicked the neighbor's dog, and the neighbor called the police, and, they charged him with animal cruelty, and it's still going through the courts, and now it's like, okay, we're going to remove him from office. Well, maybe some people would say, yay, I mean, I'm a dog lover, I don't want to see a dog kicked. Others might say, the dog was trying to bite him and he kicked them away, and are we really going to remove somebody from office for that? So, we just want to, think as broadly as we can. Misdemeanor is a lower level criminal offense. An arrest and a charge isn't the same as a conviction. And, and that's why in most cases they usually use that, duties of office thing, because it's like, well, yeah, maybe if it's a financial crime, we're going to be concerned because they're responsible for the budget and for authorizing, expenditures and stuff. So, maybe it doesn't matter at that point whether it's, oh, you bounced a couple checks, well, I don't know, is that going to be, important enough or not important enough? Now it's a financial situation, maybe it is, but I mean, we just want to make sure we don't throw out the baby with the bathwater here by making it so broad that, somebody gets a traffic ticket and they're off of council all of a sudden. We want to be careful about that.
Sharon?
I agree. I do think we have to be careful that we don't find ourselves in a situation where we want someone removed for whatever reason, and, they got a couple traffic tickets, or they kicked the dog or whatever, and now we've got 3 or 4 council people that want to get rid of that other person that maybe doesn't agree with them, and I think broadening that out opens us up to that possibility. But I did have one other question, and I'm sorry it backs up to B, but did you define moral turpitude, or what does that become defined as far as the law goes?
It's a phrase that's used a lot, and it's not well defined, but it's basically going to be, maybe any kind of sexually related crime, any kind of financial crime, fraud, anything where there's a breach of a trust or things like that. So,
So we're
but
pretty
it's
well covered.
ill-defined. So if I steal my neighbor's garden hose, and I thought I was borrowing it, but I never put it back, so it was technically considered stealing my neighbor's garden hose, is that moral turpitude? Some might say yes, some might say no, but that's why it's built in to have some sort of hearing or some sort of independent review, to say, well, does this reach that level,
But that can pretty much cover the other things that we were talking about.
It could. I mean, it's, yeah.
Are we overthinking?
I mean, no
that
crime
too
is,
much?
no crime at any level should be tolerated, really.
Right.
But we have to see that this is a drastic remedy, removing an elected official from an office that they were elected for. Okay, so I don't think anyone in here would dispute that, DUI is just wrong, period. But this court system's in place to deal with that. Do they also lose their elected position over it? Most of us would hope that we wouldn't lose our jobs over it, but yet this is a position that they were put into place through an open election. Are they going to lose that? Well, a lot of people would say yes, absolutely. If they're driving DUI in the city that they were sworn to protect, why wouldn't they be removed from office? Others would say, hey, they had 4 drinks instead of 3. They shouldn't have done that, but is this remedy too harsh? So. And this, like I said, the state always wants to default to saying, let the voters decide. That's what elected officials are supposed to be. So the removal section should be for drastic situations.
Okay, any more conversation on suspension or special hearing?
I mean, just quick thought about what she said about taking the related to duties of office. Obviously, you volunteer to, come on the committee and stuff. So I think you're held to a higher standard too, right? Any decision you make, even it comes from like you stealing to a DUI, like, hey, you made that choice, right? And then the voters had trust in you to put you in that seat. I was okay with actually leaving as felony and just for all misdemeanors and suspension and let the state figure that out and if they're guilty or not. Because ultimately, I'm sorry, but you chose to be in that position, and so how you behave out of here, you should be on a strict behavior. That's just my thought process, right? Because that would kind of cover all your other laws too. Then we wouldn't have to nitpick like, hey, we need to put this, this, and this. I don't know how you guys feel about that, but
yeah. And just dovetailing on that, because you're absolutely right as far as if somebody's committing a crime, at any level. Let's think about this though. Right now it says arrested, and there's a difference between an arrest, being charged with an offense versus conviction. At least by maybe switching this to charged, you at least have that intermediary step that this person wasn't just arrested, but whatever there's at least enough probable cause there that the state attorney filed charges. Then at that point, yeah, that process may take a year or two. We know how slow some of this stuff goes, but at least there was some, because somebody could, and unfortunately, this all too well, somebody could be arrested.
100%.
They get out the next day and they never hear about it again because the state attorney just says, yeah, there's nothing there, not going to do it, So then at that point, is that something that somebody should actually lose their position over? So I mean, we could leave it at arrest. And again, this is your decision how we want it. We can leave it at arrest. We can make it charged with instead of arrest, or we could, obviously the conviction. I mean, that's kind of a no-brainer. So.
I know some people made comments about tickets, right? Like tickets are infractions, right? In order to be charged for a misdemeanor, We have the new super speeder law, right? Council members doing over 100 miles an hour on 95, like, that's a decision they made, right? Then that's a misdemeanor. You'd be arrested for that. But just getting multiple traffic citations, that's not a misdemeanor arrest. You would have to basically be charged with reckless driving to get a court appearance, then it would go forth on for charges. So it's not just a speeding ticket if you're doing 10 miles over the speed limit. If you get 2 or 3 of them in a month, that is, you're not charged as a misdemeanor.
And they're obviously put at that level because there is a serious threat to public safety.
Yes, obviously, if it goes into reckless driving,
yeah.
then you start going into all the other stuff.
So if you
But
changed
just-
it from arrested to charged, could you remove the related to duties of office? Or should that still stay?
Oh, I think I already scratched you out when you said it the first time, but yeah, no, I mean, I mean, that, again, could be a decision of the committee here, but I think that would be something that, could be done.
Okay.
In other words, there's no requirement that it be restricted.
Could I make a motion on that and see how it goes?
You can make whatever motion you want.
Well, I didn't know if that was part of the.
So we're talking about C,
2.08C.
suspension from office, yes.
To change arrested on line 3 to charged and remove related to the duties of office on line 4.
Do I hear a second?
Second.
Any further discussion? Tim?
So I agree with everything that you said there, that when you're elected and you're a leader in the community, you are held to a higher standard. I have a couple things where, going back to getting these things through to the voter, where I think we got to be really careful on overloading the ballot with stuff. Because how many times have you gone and there's 10 things there, you pay attention to the first 1 or 2 or 3, and then you start just Xing the rest of it out. I think we got to really look at the meat, where we got to keep this to a minimum. But I also agree that we should have it misdemeanor related to duties of the office. If somebody was at a Christmas party and they had a couple drinks and they got a DUI, should they be, removed from office? I think that's up for the voter to decide really at the next election. Yeah, they made a bad choice. Yeah, I think they're held at a higher standard. But the only thing I could see, the word from arrested to charged, but I think we should keep, the duties related to the office on there. But I think we should even look from arrested to charged, because I don't want to overload this ballot with a bunch of stuff, and then all the other work that we've done that really makes a difference, go to waste as well. So just want to give you guys something to think about with that.
Well, one of the things that we also have is that if there's an issue that if you want to approve this, at the end of the day, when we finish going through all this, we're going to reconvene and have an opportunity to say, okay, so there's 15 things that we'd like to change, but we know that's overwhelming for voters, right? So now let's go through those 15 things and try to prioritize them on what we actually want to bring forward to council. So I don't think you have to constrain yourself at this point where we are. We will have an opportunity to do that later down the road when we get through.
Exactly. And after we got done with our final review, we may or may not take some of those
Yes,
supposed 15 out. But then we're also sitting at the city council, and they may take a bunch of them out.
They don't have to follow any of them.
They don't have to follow any of them.
That's right. So would you like to do your motion one more time for me?
Yes, it was for 2.08C to change arrested in line 3 to charged, and remove related to the duties of office in line 4.
I second it.
Okay, so we have a motion and a second.
I'm not sure where
Okay.
where's removed? That's in D? Is that in D?
It's on 2.08C. So it would end up suspension from office. A council member or the mayor may be suspended from his or her office if he or she is charged for a felony or a misdemeanor.
Period.
Where does remove come? You said remove on.
She said she wants to remove the words.
remove the.
Oh, okay.
She's removing the last
Remove
words.
what?
The duties of office.
Related.
Oh.
Or, yeah, related.
Oh, when I said
She's
just
hardcore
remove the
that.
related to office. That's why I said remove.
Oh,
Yeah.
okay, the last part of the sentence.
Yeah.
Does everyone understand the motion? Okay, so let's take a hand vote. All those that are in favor of that, please raise your hands. Okay, 1, 2, 3, 4, 5, 6. All those opposed? 1, 2, 3, 4, 5. We have a tie.
Oh,
Charlie, are you still on? Charles?
Mr. Stanley?
Might be in the dead zone or something.
So.
Hello, can you hear me?
Oh, there he is. Oh, well, hello. Charles, did you hear that motion?
Yes.
Okay, can you vote yea or nay on that motion?
I vote yay.
Okay. All right, so now we have 8-7, so that motion does pass. And that does remove the related to duties.
I thought he said nay.
I couldn't understand what he said.
I thought he said yea. He said he's,
Said
No,
nay.
I agree. I am in the affirmative.
no,
Oh,
okay,
okay.
he said yeah. Okay. 8-7.
That's typical.
Now, remember, we can go through this again. It's not over till it's over.
I mean, my suggestion on all of this is, you let me come back with language, then you can kind
Talk about
of,
it.
at that point, you got to kind of look at it, tweak it, and vote on it again anyway, so.
All right, so now we're at the special hearing. Did anyone have any conversation about the special hearing area?
I would tell you my recommendation on that is because I do think it might be problematic, but it's there already. It's not worth taking out. We leave it in place, and if the situation ever arises,
Deal with it then.
again, it says on advice of the city attorney, so that would be the time that I'd have to look at that and tell council, yeah, we can go ahead and do this, or maybe we don't. So I would say, it's not worth messing with right now.
All right, so we move to E, which is filling vacancies. And there is 3 paragraphs related to council vacancies. And if you've, the first one is about having a scheduled citywide election within 6 months of the occurrence. And that gives the city council, in this situation, they can either permit the vacancy to be filled at that election or appoint a replacement. Does anyone have any conversation about that? Everybody okay with one? And number 2, if there is no scheduled citywide election within 6 months of the occurrence of the vacancy, the remaining members of council shall appoint a replacement within 45 days. Anyone have a problem with that? Okay, we just changed all this last time. And if you go to the next page, it talks about if they appoint someone, that the member shall serve only till the next citywide election, or until council revokes the suspension. If it's for a suspension, then that person would go off and another one would come on. This, I know you've all prepared for this. Do you have any more conversation on number 2? Number 3 is about acquittal or found not guilty or cleared of charges, and of which they were suspended, and that council would revoke the suspension and restore the council member. Any problems with that in the charter? Okay, good. So item F is filling vacancies in candidacy. And that is about another charter section that we haven't gotten to yet. If the number of legally qualified candidates is fewer than the number of seats open for election, the new council shall fill the vacancy in office in the same manner described above in paragraph E, so you can go back to E, so it's just the same process.
I had a question.
Sure.
when Sherry won the election and we had an open seat, why didn't they seat Sherry right away when there wasn't any person running against her?
I think there's something in here about that. I read about that. What did I read about that? So that would be a you question, but I understand, no one was running against her, so she got the council seat, but she got seated at the time as if the election happened.
Right, because because when you run for office, you're running for a term. The term, even though she didn't have an opponent, the term that she won by default hadn't started yet. So pretty much.
It just seems logical that the council should have appointed her at that time to fill the vacancy.
But
they hadn't made the decision to leave it open until the election. That's probably what happened, right?
Yep.
I have a question, just kind of for clarity in case someone is watching. Where it says that if, say for instance, all right, this term we've got 2 seats up. Say one of them doesn't run for reelection, so you have an open seat. Say nobody applies to oppose the one or run for the vacant seat. How do they decide who they would appoint? Where are they going to get their appointees from? I didn't hear you.
Yeah, it goes, yeah. So at that point, they have a vacant seat, so they go back to E for filling a vacancy.
But they would have to appoint somebody before the council.
I'm feeling a little ignorant on that right now, because if you've got nobody running for an open seat, there's nobody to choose, nobody to appoint.
Well, there's 27,000 people.
So that was what I was wanting to hear.
Right.
That's kind of what I wanted to hear.
Oh, yeah, no, when it comes to filling the vacancy through appointment, council would appoint.
Councilmember A can say, I'd like to appoint so-and-so
Right.
to the city council. That's what I was looking for.
Yeah.
To know, for the public and everybody else to know that somebody on city council could call you and say, hey, you want to be on the council? Because they would be eligible. So,
Now, you looking at E and F here, it's like an evil algebra question, so.
I know.
Okay, so are you satisfied with
Oh, yeah.
So on page 13, section 2.09, judge of qualifications. Here's our judge. The Florida Division of Elections and the Florida Elections Commission, or a successor of those, or the forms. I don't know that we can do anything. Oh.
Yeah.
I'm sorry. Does anyone have any questions about the judge of qualifications, section 2.09?
Now, this would be the power that's in the state statute, so there wouldn't be anything we could do about it.
2.10 is city council employee relationships. Any conversation there? Everybody's okay. 2.11, investigations. Any questions? Section 2.12, procedure, and this is about meetings. Currently, our charter calls for city council shall meet regularly at least once a month. And it has the advanced 24-hour notice of any special meeting. Does anybody have any questions about item A, the meeting paragraph? Everybody's okay? B, rules and journal, which lets the city council determine its own rules and order of business and provides for them to keep a journal for public record. It's okay. Numbers.
In there on that, does that rule out Robert's rules?
I think he's giving you some
Still
feedback.
on Zoom.
Could you go?
Feedback.
It says rules and journal, the city council shall determine its own rules and order of business. Does that mean they could determine that they don't want to use Robert's rules anymore? And they want
Yes.
to make their own?
They can determine that, and there are a lot of municipalities that just opt out. Because Robert's Rules is a good guide, but state statute is going to take priority over Robert's Rules, so it becomes kind of a hybrid. So some cities just opt out of Robert's Rules entirely and just rely on their own rules, which have to be a little bit more meaty at that point, because there's a lot of things like making a motion and making a second and all that, you have to include that. But yeah, Robert's Rules is something that a city could adopt or opt out of.
Okay.
Could we go back just a little bit to A on the meetings? And I don't know if our manager wants to chime in about this, but one of the things that is unusual about our charter, and again, I'm not sure this is worthy of a referendum question, but I think it might want to go in the hopper and we look at it long range, is having the special meeting to be able to be called by the mayor or a council member. It kind of leaves out the city manager. And there are times when something is happening that he needs to have a special meeting in order to get council to decide something. And
But I think when we go to his role, when we go to charter officers, I think it's there.
I don't think so.
I think it is.
Yeah.
Maybe I could very well be wrong, but I do think when we go to
It's
city manager's
3.04.
power, I think he can call. Let's just see. I thought we had talked about that before. Maybe it's not, but could we put it there? Because this section is all about council. So should we make an addition of the city manager's role?
I mean, we
matter?
could, it would create a little bit of an inconsistency in the charter if one section says, oh, because the way statutory construction is usually when you list something, it excludes everything that's not listed.
Oh, but wait a minute,
So-
here it is. If a public emergency exists, any council member or charter officer may call a special meeting. It's
Right,
actually in
but that's
there.
public emergency. Not talking about something that would necessarily be a public emergency.
Oh, okay.
But just something that the manager, I mean, right now, it's not an unworkable situation right now. The manager just needs to call the mayor and say, hey, but then at that point, he's having to brief the mayor on something that the other council members aren't going to get until the meeting starts. So, so having that ability, like I said, it's because we are going to want to limit how many referendum questions we put in front of the public. It may not be something worthy of using on a question, but I think we might want to at least think about it. Unless you guys like it the way it is and want it to remain just the mayor and council that can
Mr.
call.
Benton, how do you feel about that?
I'm fine with whatever you all decide.
Oh, my gosh. I kind of thought that was going to be.
It won't come up that often, but it has come up.
Couldn't,
Anybody want to talk
well,
about that?
if Mr. Benton feels like there needs to be a special meeting, he couldn't just say, hey, Bob, could we do a special meeting? And rather than having to write a new referendum for it?
Well, I think
Yeah,
that's,
so, oh, sorry, I apologize.
I was going to say, I think that's what Jim just said, was that if Bob was to call, if Brian was to call Bob and say, hey, can we get a special meeting? He's given Bob information the rest of the council doesn't have.
Well, it happens all the time.
So what I will say is, in the instance that this happens, I would just call each of them and say, hey, we've requested a special meeting. and disclose that and that only. Don't go into too many details, because if we're requesting a special meeting, trying to not go into too far details with everything, but I will share it with every single one of them, is how I currently have to do it per the requirements.
And I don't think there's any of them that would think that you weren't call a meeting for something that wasn't important.
Any more discussion on this?
So do we want to put it out there for them to look at, or for us to review at the end? It's just one of our things by saying, can be called by the mayor or any council member or the city manager? Add "or the city manager" to it?
Yep, you can make a motion.
I'll make a motion to amend 2.12 procedures to reference special meetings can be called by the mayor or any council member, and add the city manager.
Do you, okay, is there a second?
I'll second.
Okay, so any more discussion? Richard?
Yeah, Mr. Benton, have you ever had a situation where you had it come up where you felt like you couldn't get a council member or a mayor to say they'd want to go with I think if it's not broke, we don't fix it, personally. I can't ever envision a time when a council member wouldn't go along with the city manager if there was an emergency or if there was a need for it. So I just say, if it's not broke, don't fix it.
I can think of one time.
Well, my question would be if we get to the point where we think this is something that we want to send to the voters, would it behoove us to just put the charter officers? I mean, would there be a reason for the city attorney to need to do? I mean, it just seems like if we put the charter officers, we're allowing the three folks that are really running the city at the request of the council members to be able to do this.
Right. I mean, personally, and I've been a city attorney for a long time, and it's already in here that it's in the event of an emergency, the charter officers can do it. So I can't imagine if I'm ever going to myself call a meeting, then Brian's dead. Because sorry about that. But yeah, so since it's already in there for emergencies, I can't imagine any routine situation where I think the city clerk or the city manager or city attorney would call a meeting. It's kind of the manager's purview.
So can I just rescind my motion?
Yeah, just the city manager.
Well, can I rescind my motion?
Yes, you may.
Since it really doesn't really matter to do it, I'll just rescind my motion and
Okay.
we'll move
All
on.
right.
All right, we will move on to the C. We're still at 212C, the voting, the charter requirements for the votes that are taken by city council. 3 members constitute a quorum. Everybody okay with that? 3 out of 5? And let's see, no action except as otherwise provided shall be valid or binding unless adopted by the affirmative vote of 3 or more council members. So we always have majority. Okay, moving right along. Section 2.13, emergency ordinances. So anyone have any questions? I have a question about this one. My question would be, if there's an emergency, is it necessary to have 4 council members instead of the 3 majority to be required for a vote for adoption? Because there's environmental emergencies, like storms, that could take some council member away. You know, we have a nuclear plant. There's a lot of opportunities for not being able to get 5 members of council or 4 members together in order to get an emergency ordinance passed. Just want to throw that out there. I don't know if we've ever had an issue with that in Sebastian. But is everyone okay with that? That was my only question. That's the 4. And they're only good for 90 days. All right, well, we'll go to section 2.14, codes of technical regulations. And this is about the big book of all the procedures and requirements, all the ordinances. And just say, it talks about the state law requirements. This is more I don't see a lot of stuff in here that we can do much of anything about. Anybody have any conversation here? No. Section 2.15, authentication and recording, codification and printing. This is the city clerk's job. Keeps all those books. So any conversation on A, the authentication and recording? B, the codification? Or C, printing of ordinance and resolutions and getting them out? Okay. 2.16, standing committees. We have 2 sections, A and B. Standing committees may be appointed by the city council, and their duties and powers are provided by the resolution or ordinance of the city council.
Question here.
Yes.
This is for the attorney. A standing committee can be appointed by the city council. Is there, and if it's appointed by the city council, then they have to operate in the sunshine. Is that correct?
Yes.
Okay.
That is.
Is it possible, there's committees that it would be probably advantageous for that those qualifications not to be imposed. And I'll give you an example, the Greens Committee for the golf course. You have a bunch of guys that were talking about, improving the golf course. Had we not had a Greens Committee, we would not have new greens, we wouldn't have an irrigation system there. But it was dissolved because it was set up by the city council and it had to operate in the sunshine. And I think there's other types of committees that perhaps, like a safety committee of people that are involved in the airport, that it would be advantageous from the city to have them not have to meet in the sunshine and still come to report to the city council. Is that possible?
Not really. Not to report, well, not to direct, not to be appointed by the city council. What we could probably do is to allow certain committees to be set up by the manager. They would have to be strictly advisory. They could have no power. Sure. They would just, talk about ideas and give them to the manager, and then they would filter, depending on how they're handled, they might filter up to the council for a decision, but it would be the manager bringing it, saying, oh, we decided to, paint all the grass at the golf course orange or something, but it would be him bringing it to the council, not the committee. The committee, whatever it is, would be kind of an advisory to him as a manager, and even then you got to be careful, because that's, like I said, they can't have any real power, because if they're making any decisions, then it becomes a sunshine situation again. So
well, both the airport and the golf course operate as different enterprise zones, I guess.
Zones, right.
So I guess it would be possible for the manager of the golf course and the manager of the airport to have a
And like an
cadre of people,
advisory-
advisory committee.
Yeah.
Okay.
Anyone have any other comments about standing committees?
I just want, the standing committees, that would include like P and Z and Park and Rec, and are those considered standing committees?
I mean, in the broadest sense, yes, but most of those exist because of some other requirement in the law. Like
Okay.
our planning and zoning board is our local planning agency, which state statute requires us to have and things like that, so.
Okay.
These are more ad hoc type things that they might set up, like you guys, for instance.
Yeah. We're done with section 2. So yeah, I think we're going to stop there, but then let's go to staff matters. Do you have anything?
Well, I'm glad we matter, but no, I have nothing.
Do you have anything? I do. For the clerk's office? Okay, so committee member matters. So we don't have a meeting until March 2nd, so we have a couple of weeks off. And I would ask you to think about Article 3 and 4, and maybe if the city attorney can send us some stuff through the clerk by email,
Yeah.
so that we can prepare for some of the things that we tabled and put to the side. And then we'll go back to our unfinished business, which is going to be the eligibility section. We'll talk about that again. And then we'll start on Article 3, the administration and legal departments next time. Does anyone have anything for the committee before we get a motion to adjourn? A motion to adjourn. Second, we are done.